and welcome to MoLawNow. My name is Scott Lauk, senior reporter for Missouri Lawyers Media. Today I'm speaking with Chuck Hatfield, partner with Stinson in Jefferson City. Chuck is one of Missouri's top lawyers on election law, and he's going to walk us through two important voting rights opinions that came out on Friday, October 9th. Chuck, thanks for being here.
Thank you, Scott. Good to see you.
Just to start, can you sort of briefly walk us through the basics of the two cases that came out on Friday, one from the Missouri Supreme Court and the other from the U.S. District Court in Kansas City?
Sure. So the case in front of the Missouri Supreme Court, which was brought by the NAACP, represented by the ACLU, challenged Missouri's requirement for notarization of certain ballots. So, you know that during the pandemic, the legislature has authorized expanded absentee balloting and has also authorized mail-in balloting. So anyone, regardless of whether you have an excuse, regardless of whether you're going to be in your county on election day, may vote using an may vote using a mail-in ballot. But those mail-in ballots have to be notarized. Well, notaries charge sometimes, and in fact, some laws on voting say they cannot charge, but for mail-in balloting, they may charge. And notaries can be hard to find, particularly in a pandemic. And so the NAACP alleged that notarization requirement was an infringement on the fundamental right to vote. The Supreme Court, the first part of their reasoning, I thought was pretty important and sort of new, or new, but legally significant in a newer way. They said that mail-in balloting is the same as absentee balloting, and I'm not sure if I necessarily agree with that. But this new thing we have called mail-in, they said was absentee. Well, the law is pretty clear that absentee voting is not a fundamental right. It is a privilege. And that's been clear under Missouri law for a long time and under federal law for quite a while as well. And so the court then analyzed a rational basis type framework and found that the state had a basis for requiring notarization. I should add that Missouri is one of a very few states that require notarization. You can look this up, Scott, but I think it's fewer than 10 states that require notarization on absentee ballots. So that's the Supreme Court case. The federal case, which was in front of Judge Wimes, and I'm sorry, you may have the parties in that case down better than I do, but Judge Wimes entered a TRO, and so that case was at the early stages. And as I understand that case, the issue there had to do with equal protection and has to do with the fact that for mail-in ballots, the legislature said those have to be delivered to your election authority by mail. As the Attorney General's office likes to say, it's right there in the name. It's a mail-in ballot. Well, the problem with that is that most absentee ballots, which to voters seem like the same thing, in fact, I said most, but all absentee ballots, you can hand deliver them back to the election authority and bring them in and personally hand them in. You may not do that with mail-in ballots. So if you try to bring your mail-in ballot into the election authority and say, here it is, I'm here, please take it, they will send you away and tell you that you have to go to the post office and submit it that way. And right. Judge Wimes said there, as I understand his opinion, which was fairly quick, again, we're in a TRO context, there really isn't a rational basis even as to why you would require mail-in ballots to be mailed in versus handed in, whereas absentee ballots can be handed in. That ruling is administratively stayed at the moment, pending briefing on a full stay before Judge Wimes and the Eighth Circuit.
Now, obviously, it's too early to say exactly how that would turn out, but I do know that the U.S. Supreme Court has been pretty leery of allowing federal courts to make changes to election laws so close to an election. I don't know where this falls in that spectrum of allowable action at this point, but that seems like something that'll be an issue going forward.
Definitely be an issue. So a couple of observations on that. First is that the mail-in balloting, at least, is a new process that the legislature adopted. Now, could these plaintiffs have sued a little earlier? I mean, one can argue about that, but it's not as if this is an election law that's been on the books for the last 10 years and plaintiffs are now challenging it. These mail-in ballots are a new process that was first used in the August primary. The NAACP case, at least, I believe, was brought in August. And I think, I think it's an interesting dilemma, right? How do you sue over a law that's brand new and you don't know how it's going to work? NAACP case was brought shortly after the August primary. That to me seems reasonable. You've got to see how it worked during an election before you really have a challenge to it. But you're right. The U.S. Supreme Court has been reluctant to make changes. Missouri Supreme Court is not as much. The Weinshank case was fairly late in the process. Priorities USA, which was a Missouri Supreme Court case in 2018, I believe was a September case. And then just one other thing on that. I think that the plaintiffs in both of these cases are arguing that the changes they're looking for are not really the types of changes that the U.S. Supreme Court was talking about. They're not likely to confuse voters. All they're really asking, the notary requirement, maybe this doesn't apply, but all they're really asking for is that certain ballots that folks turn in are in fact counted. So, people could still, on the mail-in ballots, for example, you could still mail your ballot in, as I understand their theory. It's just that if you chose to bring it in, they would need to count it. There's another case pending in front of Judge Dan Green that's even later in the process, and he's expected to rule early this week, where it's called American Women versus Ashcroft, interestingly enough. And in that case, they're talking about how to count ballots after the election. In other words, if a ballot is in the hands of the election authority on election day, do we go ahead and count it or do we not? And in that case, the argument would be that, it's not upsetting the election rules. It's just talking about how you would count after they're turned in.
Right. There seems to be a big difference between, say, requiring the state to, continue to count ballots that come in X number of days after the election is over, or something like that, which I believe was the holding in one of the cases that has, been subject of some of the Supreme Court precedents on that. The argument I know specifically was made in the Missouri Supreme Court case, and I assume in the federal case as well, is that you're sort of just giving the voters a wider leeway. You're not really requiring the state to do anything different than it otherwise would. You're not qualifying folks who weren't qualified to vote, something like that. I guess that kind of exists maybe on a spectrum, and it'll sort of depend on where on the spectrum the Eighth Circuit or the Supreme Court or both think it falls.
Right, and I'll confess, I haven't really studied the Supreme Court's theories on not changing election laws, so close to the election. In fact, I can't even name the doctrine. There's something they call that, right? There's a specific doctrine. But I got to tell you, I'm not sure I fully understand the logic of it. I mean, if a practice of a state or a law of a state is in fact unconstitutional, if it in fact deprives someone of their fundamental right to vote, I'm not sure I follow why a court cannot make a ruling and provide a remedy on that, up to the day before the election.
Yeah, I mean, I guess the argument in favor of the Supreme Court's position is that the more you do that, one, you're taking the rules for voting out of the hands of the legislature and putting it in the hands of the commission. And two, that you do risk confusing voters because you have sort of an ever shifting set of rules on what's allowed and what's not.
right?
On that point, I know voter confusion comes up a lot, and there's a certain logic to saying something like, well, if we just count all the ballots that come in, for instance, like the NAACP case, if people got theirs notarized and they sent them in, great, count them. If they couldn't or didn't do that, just count them, and just basically ignore that portion of the requirement, and nobody gets disenfranchised and nobody's really put at a disadvantage. But when you have all this litigation and these sort of ever shifting, yes, you can do this, no, you can't do this, does that, does that in some way disenfranchise voters because they just don't know what it is that they're supposed to do to successfully cast a ballot?
Well, I I don't know about that. I went and voted absentee this year under one of the exceptions, and uh, because I'm really interested in this stuff, I sort of hung around for a while and watched people vote absentee, and then I actually took a friend over to vote absentee here in Cole County. Voters don't know. I mean, one voter walked in and they asked, "Why do you wish to vote absentee?" Which is what they should ask, and he said, "I don't know, my civic duty." And I heard other voters who said, uh, I take some medication, which I had no idea what they were talking about, and they gave him an absentee ballot. Um, I don't know that voters really follow all of this, and my perception is they think they ought to be allowed to vote as a general rule. I mean, nobody thinks I shouldn't be allowed to vote. It's always somebody else who shouldn't be allowed to vote. So I think that generally voters don't spend that much time, trying to figure out the nuances. What this comes down to is, are there these voters who have been confused and haven't fully complied with the law? And if so, are we going to count their votes? Or are we not going to count their votes? The confusion kind of goes to the injury. What's the injury? How likely is it that this is really happening out there? And I would digress slightly on the state side of this argument. The statistics so far are that there are not overwhelming numbers of mail-in ballots. That's the not no excuse, just get it and mail it in. Now, people have different theories on that. One theory is that nobody trusts the post office right now, so they're not going to mail them in. Absentee balloting in Missouri is through the roof. And absentee balloting is, voters, I think, are more familiar with that process of absentee balloting. A lot of folks are doing it, what they call in-person absentee balloting, which seems like a bit of an oxymoron. But, my experience in litigating some of these is that the local election authorities are very helpful. If somebody goes in and wants to vote and they're there, the election authority will help them understand. So I think voters are, I don't know if I'd say they're figuring it out. I'm not sure it really bothers them that these rules change on them.
Right.
But Scott, one other thing I might mention at the risk of hijacking your outline of questions, it is really odd to me if you follow what goes on nationally, and this year we got a lot of litigation that, the voting rules in Missouri are different than the voting rules elsewhere. And I think people are surprised to hear that. There's a story out today, I think in the Washington Post, about the cure period in North Carolina. And so the issue is, if you send in your absentee ballot and you forget to sign it, or you forget to notarize it, or you forget to put your address, I don't know what the other issues might be, can you fix that? And Missouri does not have a particular law on whether you can fix that problem if you did it incorrectly. Some states do. And I'll tell you that what I've learned is in Missouri, it's different. Some counties, if you send in an absentee ballot and you forgot to sign it or notarize it, they will call you and say, you forgot to do this. Do you want to fix it? Other counties don't think that's appropriate. So I think it is odd and a little bit potentially confusing for voters that we don't really have uniform rules on exactly how this works across the country.
Right. Um, And I mean, to your point about people are choosing absentee over mail in, that makes a lot of sense, just because as you point out, most people don't follow this on a really strict basis. So people have heard of absentee before,
Right.
and they show up, and if the county's willing to give them an absentee ballot, then that's what they'll do.
That's right. The other interesting, since we're talking about absentee ballots, the other interesting aspect of the Missouri Supreme Court's ruling this week was Judge Wilson's concurrence,
Yeah,
in in, in which Judge Wilson said, uh, I think this is pretty close paraphrase, that the party's efforts might be better spent educating voters rather than litigating the issues. And I think fair um, a fair understanding of what Judge Wilson was trying to say is that absentee voting is a lot easier than we think it is. The language of the statutes, the language of the statute on absentee balloting begins if a voter expects to be paraphrasing, unavailable to go to the polls on election day due to, one, absence from the jurisdiction, two, illness, and then there's others, religious exemptions, et cetera. But what Judge Wilson said is, there's no reasonableness requirement there. So if you live in Jackson County and you expect to go visit your grandmother in Kirksville on election day, even though your expectation may not be very reasonable and you might not really end up going, you can still vote absentee. And he did this on the context of if you expect to be ill and how it doesn't have to be reasonable. I have to say, when you think through the semantics here, I expect to get COVID at some point. I think that's, I work very hard not to, but I think, and it may be an unreasonable expectation, but I kind of expect it's going to happen to me at some point. And so I think what Judge Wilson was saying there, and because this was about COVID, if you expect you're going to be ill, and if you expect you're going to be ill on election day, then you can vote absentee. And your expectation doesn't have to be, again, reasonable, or I would say it doesn't have to be that high. I did not use the I expect to be ill exception when I voted absentee, but I think I probably could have. I expect to be ill and on election day. I think I do.
Yeah, Judge Wilson's concurring opinion kind of backed up something I've long thought, which is that whether I think a lot of people are just going to vote absentee this year, regardless. And I don't see a lot of local prosecutors putting a lot of time and effort into going after those people. Um,
Right.
and Judge Wilson's concurring opinion, it seems to kind of back up the idea that this would be a very, very difficult case to prove, because you'd have to prove that the person knew for a fact they weren't going to be ill or incapacitated or absent on that day. And as you point out, that would be a tough burden to overcome, I think, under normal circumstances. And in the current circumstances, it just doesn't seem like something that local prosecutors would be all that interested in. So,
And I think local election authorities are, they're not conducting a cross examination. If you show up and say, I'm going to be absent. I was telling you my story about watching people vote. One person walked up to the counter and said, "I would like to early vote, please." Right? They don't know the difference between early voting and absentee voting and all that. And so there was why, and I don't remember what he said, honestly, but generally they're pretty lenient, I think, at those desks, and they're not going to question whatever your reason is.
right. So, but of course, it's one thing to say that it's extremely unlikely that prosecutors are going to go after folks for doing this. It's another thing to be a voter and to know that you probably could show up at the poll on that day, but you prefer not to, and so you're telling a white lie or a half truth or something like that in something that is making you attest to the truthfulness of what you're saying. I on a systemic level, I don't think a lot of people are going to get prosecuted for that, but I can also see why voters would be leery of doing that absent something that says this is okay.
Right. No, I think that's right. And I think that to get maybe just a little extra political because it's a political topic. I think there probably are groups of voters who are, how should we say, more afraid of the government than others, who might be reluctant to go in and say, you know, to voice an unreasonable expectation, to use the phrases that Judge Wilson has used. Whereas there are other folks who may be more well privileged and used to dealing with the government, who are going to say, yeah, it's no big deal. All the things you just said, Scott. Nobody's really going to challenge me, so it'll all be fine. And so there may be certain voters who are affected a little more by what we call fault absentee as opposed to no fault absentee balloting.
Um, Given that absentee balloting is, pretty much through the roof, as you said, and that we do also have people using this newfangled mail-in voting scheme that, as of now, may or may not require them to actually drop it in a mailbox. How concerned are you about ballots being disqualified for technical reasons? Lack of signature, still with absentee, lack of mail-in voting, lack of notarization. There was, I believe it was a municipal election in New York, but it was something like a quarter of the ballots that were mailed in were disqualified for one reason or another. That's just astonishing. But when you think about the sheer number of ways that people can mess up paperwork, that kind of starts to make sense. When you walk into a polling location, the poll workers basically make sure you do everything right because they don't give you the ballot until you've done everything right. But just given where our laws are right now, do you have concerns that we're going to see hopefully not a quarter, but some substantial portion of absentee ballots that are disqualified, and then the fears of what comes as a result of that?
Well, yeah, let me make a comment on something you just said. Secretary Ashcroft is fond of saying that the gold standard for voting is in-person voting on election day, and that's right. I mean, I don't think anybody can argue that if your sole concern is being sure that your vote's going to be counted, the best thing to do is to walk into that polling place, and as you said, personally vote. That's not everybody's sole concern. A lot of people have completely legitimate concerns. So they're looking for absentee and mail-in as a way to make their vote count, but also protect themselves. And I do worry a little bit about the disqualification, but I guess I don't worry in Missouri that we're going to have wholesale disenfranchisement. What I do, because I haven't seen that historically. Now we might this year. What I do worry about is lack of uniform standards. So what I do worry about is that you might have an area that is controlled by one party. So you have a Republican county clerk who applies a very strict interpretation of the law, doesn't call voters and ask them to cure things. And so you've got a whole group of people, you've got a higher, you've got a higher disqualification rate in that county because of the way that clerk does it. And then maybe you've got a Democrat clerk who goes to every effort to try to correct ballots, try to let people know. And so you get something that's skewed. I mean, my experience with dealing with voting, irregularities after the fact, election recounts and election challenges and that sort of thing. There's so many people voting that it all sort of works out in the wash, right? I mean, it's such a huge number that these little errors around the edges are not going to change the outcome of an election, except in, Bush versus Gore once in a lifetime circumstances. But what could change an election is different standards applied in different areas, so as particularly partisan areas where you have heavy Republican or Democrat vote and the standards are different. And I do worry a little bit about that because we see the Secretary of State has statistics on this. And, we see that there are certain counties that have much higher rejection rates on absentee ballots than others. Personally, I don't consider them alarmingly high. but statistically, some counties have higher rejection rates than others. And that's not because their citizens don't understand, right? That's because the county clerk's applying a different standard.
Right. Right. Well, Chuck, thank you. Thank you so much. I really appreciate you taking the time with us today.
No problem. Happy to do it.
Well, once again, our guest today has been Chuck Hatfield, Stinson in Jefferson City. And I'm Scott Lauk for MoLawNow and Missouri Lawyers Media. Thank you.